as John reminds me, we do have an audience that is streaming, so they're probably sitting there getting onto the second whiskey. Right. Right. Good evening, ladies and gentlemen, and welcome to the 45th Hoernlé Memorial Lecture. And I won't say anything about it other than to be very pleased that the IRR, in association with the Free Speech Union of South Africa, is bringing the lecture to you and re-establishing, I think, a very nice habit, hopefully. I'm Sarah Gon. I'm the director of the Free Speech Union, and it was an apposite subject to associate with the IRR, even though we are a unit of the IRR. So welcome to one of the loveliest sites in Joburg, and jacaranda season. So we have a plethora of jacarandas, even if we don't have a plethora of municipal services to benefit us. I think the essence of the lectures are very much, since inception, have involved the issues of race relations, classical liberalism, and the future of South Africa. And so essentially nothing has changed. And if we can get up some steam, maybe by the 100th birthday of the IRR, we can have the 50th anniversary Hoernlé lecture. And a special welcome to Hoernlé grandchildren who are present this evening. The order of the program is simply going to be that John Endres, our CEO, will give introduction, introduce a speaker, and give you a little bit of history about the lectures. Then Mark Oppenheimer will speak. We'll do Q&A, and Paul Pereira has kindly agreed to give us a vote of thanks. And after that, we'll have some drinks and some snacks and hopefully some lively conversation. I just, though, wanted to take the opportunity to thank the IRR people who helped me put this together. Present are Mbali Maisela and BK Tukani, who are doing all our video work and design for the invitations, etc. Stuff that is not in my area of expertise, so they were great help. But particularly to Taylor Bornman, who did most of the organization of the actual event, the physical stuff you see, and Talia Bayers, who helped with communicating to our IR members, to readers of the Daily Friend, and such, and helped again with some of the technological stuff that I don't really know very much about. So as a consequence, I'd also like to welcome the audience that is streaming live, and to say that this event will be recorded. So the recording will be available for those who can't make it. Please, I expect because of traffic, we're still waiting for people, so I'll let them just come in. Please don't be too bothered by people if they do come in. And otherwise, I'll hand you over to our CEO, John Endres.
Hello, everyone. So ladies and gentlemen, esteemed guests, welcome. And a special welcome also to the grandchildren of Alfred and Winifred Hoernlé, who join us here tonight, and we're very pleased to have them here. 79 years ago, a group of liberals gathered to hear Jan Hendrik Hofmeyr deliver the very first Hoernlé Memorial Lecture, much as we are gathered here today. Our predecessors were interested in the same things that we are interested in today. They wanted to know what was going on in South Africa. Through the Hoernlé Lectures, the liberal community has been privileged through the years to hear thoughtful assessments from knowledgeable speakers about the situation in South Africa. So let's take a bit of a dive into the past as we find out about the Hoernlé Lectures. In the inaugural Hoernlé Lecture, for example, Jan Hofmeyr, who at the time was the IR vice president and honorary life member, spoke on the topic of Christian principles and race problems. Other distinguished speakers over the years included Archbishop Dennis Hurley on apartheid, a crisis of the Christian conscience in 1964, Chief Mangosuthu Buthelezi on white and black nationalism, ethnicity, and the future of the homelands in 1974. Dr. Alan Payton on Towards Racial Justice, Will There Be a Change of Heart in 1979, and again on Federation or Desolation in 1985. And he was the only speaker so far to have delivered 2 Hoernlé lectures. Professor Jonathan Jansen spoke in 2005 on When Does a University Cease to Exist? And Professor R.W. Johnson, Bill Johnson, in 2011 on the future of the liberal tradition in South Africa. For me, this is the 3rd Hoernlé lecture that I'm attending in person, and the 2 that I have been to in the past really left a deep impression. I heard Otto Count Lambsdorff, a famous German liberal and friend of South Africa's, warn of the risks of the welfare state in 2006. Speaking from the European experience, he warned that, quote, the growth of social grants in South Africa will not come to an end in the foreseeable future. And he then quoted Trevor Manuel, who was the finance minister at the time, as saying, is our vision of a future South Africa one in which over 20% of the population depends on welfare for their livelihoods? And apparently the answer was yes. For today, 50% of households in South Africa receive at least one social grant. And for 25% of households, social grants are their primary source of income. In a similar way, many Hoernlé lectures gave their audiences glimpses of the future. In 2011, in this very place, I heard Professor R.W. Johnson speak on the future of the liberal tradition in South Africa. And I learned that liberalism has much deeper roots than I was aware of. The following observation of his has always stuck with me. He said, South Africans of all races have long ago crossed the frontier into what one might call a liberal way of life. Even the most loyal ANC activists assume they live in a country where consumer sovereignty prevails, where people are free to say what they want, move where they wish, practice the religion of their choice, read or watch the media of their choice, and decide their own family size. These freedoms are very deeply ingrained into the everyday life and thought of all South Africans, and they are simply not negotiable. This is something which ought to give one enormous confidence in the future. Liberals have often had a tough time in South Africa. Many of the Hoernlé lectures convey a sense of anguish about the intractability of the country's problems and the intransigence of those in charge. To read the historical Hoernlé lectures is to absorb a strong sense of the times in which they were delivered. And I encourage you all to visit the IRR website, where thanks to the efforts of BK, and Tyler and colleagues, you can look up the Hoernlé lectures. They are posted there for you to look at under the About Us menu. Who were Alfred and Winifred Hoernlé? Well, Professor Alfred Hoernlé shaped the Institute in his capacity as council president from 1933 until his death in 1943. And his wife, Dr. Winifred Hoernlé, was president from 1948 to 1950 and vice president for many years more. And they both made an enormous contribution to the Institute. From the biographies and obituaries I've read, they come across as exceptionally kind and warm-hearted people. They left a lasting impression on those who met them, and it is not surprising that the Institute decided to establish a series of lectures in their honor. They were a genuinely impressive couple, each in their own right. The Routledge Encyclopedia of Philosophy calls Reinhold Frederick Alfred Hoernlé, to give him his full name, perhaps the best known of South African philosophers, and writes, Hoernlé's most significant contribution was in the application of liberal political thought to the multi-ethnic environment of South Africa. He became associated with the Institute in 1932 and served as its president for 9 years, until his death in 1943. He was born in Germany, in Bonn, but spent his early childhood in Calcutta, in India, where he became fluent in Hindi before returning to Germany with his parents. His schooling was German, but his university studies were English. So he attended Oxford, graduating in 1905, at the age of 25. His academic career then took him to the University of St. Andrews, University of Cape Town, King's College at Newcastle on Tyne, Harvard University for 6 years, back to Newcastle, and then he became a professor of philosophy at the University of the Witwatersrand from 1923 to 1943. And in his introduction to the inaugural Hoernlé Lecture in 1945, the IRR director at the time, J.D. Reinald Jones, wrote, "In Hoernlé were combined several outstanding qualities. Gifted with a brilliant analytical mind, he was able to trace more clearly than anyone the single threads in the tangled skein of our racial situations. At the same time, his aptitude for administrative work made him ever willing to tackle practical problems, whether in academic organization, in racial situations, or in such specialized activities as the educational work for the Union forces, which he initiated during the present war." That was the World War II, of course. He was an outstandingly good lecturer and public speaker. As a philosophical thinker, his reputation stood high in Europe and America, and there's no doubt that his deep concern for the future of the Union of South Africa and the welfare of its underprivileged people led him to turn aside from an even more distinguished career as a philosopher. Alfred Hoernlé's hard thinking and practicality, together with a rare combination of the scientific spirit and humane sympathy, which his own thoughts and thinking about race relations reflected, set the stage for others in South Africa and the continent to see the possibilities of realizing the main objectives of the IRR, which are to work for peace, goodwill, and practical cooperation between the races. His wife, Dr. Agnes Winifred Hoernlé, born Tucker, was a South African anthropologist, widely recognized as the mother of social anthropology in South Africa. She served as president of the Institute from 1948 to 50, and as vice president for many more years. And in an appreciation written in 1960, the social anthropologists Gluckman and Shapira wrote, "Mrs. Hoernlé was a brilliant, inspiring, and warm-hearted teacher who not only excited in her students an enthusiasm for the subject, but developed close, affectionate ties with them." She was born in 1885 in Kimberley, in the Cape Colony, as it was at the time. But she moved with her family first to Johannesburg, then to East London at the outbreak of the Boer War, before matriculating at the Wesleyan High School in Grahamstown in 1902. After earning an undergraduate degree in philosophy, classics, and French from the South African College, which is now UCT, in 1906, she studied anthropology at Cambridge and attended courses at Leipzig University, the University of Bonn, and the Sorbonne in France. Professor Loveday, who held the chair of philosophy at the South African College, so UCT today, later wrote of her, "She followed a combination of critical and constructive powers, unusual at her age. I can say without hesitation that of all the students in philosophy whom I have anywhere taught, she was by far the most capable." Upon her return to South Africa in 1912, she undertook field research among the Nama, a Khoi group in the Cape Colony and Southwest Africa. And she married Alfred Hoernlé in 1914 at the outbreak of the First World War, and they moved to the United States, where her husband taught at Harvard University. And their only child, Alwyn, was born in 1915, and he was, of course, the father of the Hoernlé descendants we have with us today. In 1920, they returned to South Africa, where she partnered with Alfred Radcliffe Brown, an English social anthropologist, to establish social anthropology as an academic discipline in South Africa. In 1923, she became the first lecturer of social anthropology at the University of the Witwatersrand. She trained many of the leading social anthropologists of her era and laid the foundations for the development of social anthropology in the country. She retired from teaching in 1937 and spent the rest of her life focusing on social reforms. She received numerous accolades for her academic and social work, including an honorary doctorate of law conferred by Wits in 1949. She opposed apartheid, arguing in reports to the government that all cultures composing South Africa's society had intrinsic value and that no race was superior. She advocated for liberal values such as equal opportunity regardless of race, freedom of expression, and the rule of law. As she wrote in an editorial in 1950, quote, "Never resting, never tiring, It is the duty of liberals to devote their initiative and their energy to the achievement of free minds in free societies. All of this is to set the scene for this evening's 45th Hoernlé Memorial Lecture, and we are honored indeed to welcome Advocate Mark Oppenheimer as our speaker tonight. Mark is the IRR Council President. He's a practicing advocate and a member of the Johannesburg Bar, has appeared in the Supreme Court of Appeal and the Constitutional Court in a series of cases that seek to determine the boundary between freedom of expression and genuine hate speech. He's frequently a guest on South African television to discuss human rights and the rule of law. He co-hosts the popular philosophy podcast, Brain in a Vat, and was recently elected as a member of the UCT Council. Tonight, he will share his thoughts on the challenging intersection of free speech and hate speech. Hate speech has become increasingly prevalent, fueled by social media, political polarization, and the rise of extremist groups. It can have a profoundly negative effect on individuals and communities, causing harm and inciting violence, perpetuating discrimination. However, defining it is notoriously difficult. So Mark will discuss, I believe, real-life court cases involving flags, demands for an end to gay marriage, and songs calling for the slaughter of ethnic minorities. Along the way, he will uncover the value of freedom of expression and determine whether it should ever be limited. Please join me in welcoming Advocate Mark Oppenheimer as he delivers the 45th Hoernlé Memorial Lecture.
Well, thank you so much to Sarah and to John for asking me to speak tonight. It's an immense honor. I'm going to start off with a legal quote, which some of you may recall, which is, in relation to pornography, I can't define it, but I know it when I see it. And I think people have a similar feeling about hate speech. One of the views is that really it's speech that I hate. And the danger with speech that I hate as a definition is that it's incredibly personal, that we will feel this strong sensation inside of ourselves that there are certain things that we despise and we want to ban it. And if we can give it that nomer of hate speech, we can then use the power of the state or the power of society to say this speech must be driven away. And so it seems immensely important, if we're going to be regulating speech, if we're going to be imposing criminal sanctions or civil sanctions, financial penalties, that we should know what it is that carries the marker of hate speech. But before we get there, I think it's important to recognize the value of free speech. And we are very fortunate to live in a country that recognizes that value in its constitution. South Africa has one of the more liberal constitutions in the world. And part of that is because we come from a time where free speech was not seen as sacred, that we had enormous amounts of censorship during apartheid. I often think about the kinds of things that were on banned lists. The first thing I'd like to ban would be Windows 95 because those dings are just so terrible. But the kinds of things that were on banned lists would be like books like Black Beauty, because are we good? Okay. So books like Black Beauty, not because they were about a horse, but because they extolled the idea that maybe black people could be beautiful. That certain records would have areas of them scratched out so they couldn't be played on public radio. The long lists of ideas that were hidden, of images that were banned, it's rather astonishing to think about the history of thought control and censorship. And that's partly why our Constitution prizes the value of free speech. And so we say that all South Africans, all citizens have this right to free speech, and that includes freedom of the press. So, at times newspapers played an important role in being able to uncover some of the terrible things that governments do, either during apartheid or now, and it's important to give them that freedom to do so. Academic freedom is specifically mentioned as a scientific inquiry, and the idea of the university really is that it's the place where people can say the unutterable. They can explore ideas that are strange to the rest of us, and they're given that space in the ivory tower to do so, and that you want to protect that. Artistic freedom is specifically protected, as is the artistic process. So it's not just the end product of the work of art, but the journey that you go on. So these things are specifically enumerated in our Constitution. Now, why should free speech be protected? There's a couple of traditional reasons, and the one is that it's a very good way to find out what's actually true in the world. That if you let people say things that are false, that they will clash their sword against someone else. And in that combat of ideas, we will find out what's true. And it might be that the false idea will last for a while, that it might take some time for it to topple. And it might be that certain true ideas will disappear for a long time before we're able to rediscover them. But if people are free to speak, your chances of being able to find out what's true are just much more likely to occur. And this might not just be in the space of moral ideas, but in terms of finding out the nature of the world that we live in, or about how things are happening. Some of you may have seen the TV series about Chernobyl. And that series is partly about a nuclear disaster, but it's partly about the consequences of a culture of fear where people don't feel free to speak their minds. So those Soviet scientists were so worried about speaking the truth that it was an unutterable thing to say that there is a problem. That the first opening scene of that series is to say that we've had this nuclear reactor implode, and someone says it's not possible. It could not be that way. And so people are staring reality in the face, but the consequence of uttering what's true is so bad that you deny it. And of course, people die. At various stages in history, people have been persecuted for saying things that were true. If you said that the earth is not at the center of the world, that would have been a heretical thing to say. If you said that black people and white people ought to be able to get married, that gay couples should have the right to get married, these things were seen as unutterable. And free speech was one of the ways in which these ideas could disseminate and people could change their minds. So trying to find out what's true is really important. Something else, which is that if you value yourself as a human being, that if you're able to exercise agency, it's important that you're actually able to do this deliberation, that you have access to information, that things aren't kept from you, so that you can work out, is this a good idea, is this a bad idea? If everything that's sent to you is filtered by the state or by your friends or by your family, it's hard to say that you lead a life of dignity, that you're not able to make genuine choices if things are hidden from you. And so in order to be a free human being, in order to lead a life filled with agency and dignity, it's important that you have access to information, that you are able to speak your mind and find out what others have to say for themselves. Similarly, democracy itself depends on free speech, that you want to know what are the views of those that are running for political office. What do these different political parties believe? Are they the kind of people that you should support? Often I think we see things said by political parties that shock us. We find incredibly offensive, and maybe some of us even feel the view that they shouldn't be allowed to say that. But it gives us important information. And one way to ensure that those politicians never climb up to the ranks of having total power is to hear them out and not vote for them. So democracy really flourishes in sunlight when you can see some of the dangerous, despicable ideas being expressed by people. There's also a sense in which you want to have a culture of tolerance. Now, often people speak about tolerance as if, well, we tolerate things that we like. So, I tolerate sunsets and butterflies and unicorns. No, you tolerate things that you dislike. I'd say, I really don't like your taste in music, but I'll tolerate it. I think you should be allowed to listen to your own music. And what we found over time is that there has been a narrowing of what we're willing to tolerate. The kinds of ideas that people are able to express publicly has shifted quite dramatically. Things that might have been perfectly acceptable to say 10 years ago might now be seen as beyond the pale. And we partly see this in that for the last 15 years or so, people have led their lives in some way online. And so there's a public record of things that they've said on Twitter or on Facebook or on YouTube. And some of those things then get resurfaced. And the things that were acceptable to have said 15 years ago are now viewed as utterly despicable. And so there might have been a culture of tolerance then, but not now. Why should we tolerate some of the horrible things that are being said? Well, some of it is that it's free information. I often think about, in South Africa, we don't have a rule that you're not allowed to wave a swastika. There's no law that bans the waving of swastikas. Now, I think if you wave a swastika around, you're doing something really despicable. My grandparents escaped Nazi Germany. They lived under the yoke of Nazism before they fled South Africa and were able to lead free lives here. And so I think if you wave a swastika, you do something despicable. But we almost never see it. And when we do see it, we get free information. We know that there's a problem. We know that this is something that must be combated. And so on the rare occasion that one is scrawled at a university, as happened on occasion, the community can sort of say, there's an issue here. There needs to be more education on this front. And Sebut Lamini, who was the SRC president at WITS, had said that he was a friend of Hitler. And the view was to say, maybe you don't know what you're saying. Maybe you don't have a sense of history. And so the Holocaust and Genocide Center invited him to come understand what that meant and to engage with the horrors of the Holocaust. And he changed his mind, and he publicly changed his mind. So allowing people to say some terrible things can often be quite useful for finding out, how dangerous things are and how to combat them through non-legal means. So I've given you an idea of why free speech matters, but our Constitution doesn't stop there. It says there are 3 grounds where you don't have a right to free speech. So the first is propaganda for war. The second, the incitement of imminent violence. And the third being the hate speech clause, which is the advocacy of hatred based on race, gender, ethnicity, and religion, and that constitutes an incitement to cause harm. So let me just unpack some of that. So let's think about propaganda for war. You're dealing with a catastrophic form of harm. The idea of war involves an enormous amount of violence, a clash of civilizations. It's something that we want to avoid. Incitement of imminent violence. So the idea is that you are calling on someone to perform an action that will result in violence now. So John Stuart Mill, the famous liberal philosopher, imagines the following case. He says, you're standing in front of a very angry mob who have surrounded a corn dealer's house, and they're carrying their pitchforks and their lanterns, and you say to them, you need to rise up against the corn dealer who is oppressing you, and you need to do by any means necessary that which will ensure that you have justice. And there's a very good chance that in this moment that they're going to use those pitchforks to kill the corn dealer and burn down his supply of stock. And so Mill thinks there's a reason to prohibit that speech in that moment. But he says if you were to say an absolutely identical thing in the newspaper, where the crowd is separated out, reading the newspaper while eating their bacon and eggs, that there's no chance of imminent violence. And so therefore the speech could be protected. So then we have the hate speech clause. And you'll note that you have the advocacy of hatred. So you are calling on those 4 limited groups for hatred to be visited upon them. And you're calling on the incitement of harm against those groups. So you're saying to one group of people, these people are despicable, they should be hated, and you should do something about it. And that thing doesn't have to amount to the level of violence. It doesn't have to be now, but it must be a harm. So that kind of gives us an idea of what the Constitution says about the framework. Now, I think a lot of non-lawyers view the Constitution as the foundational sacred document and the end of the story. They're half right. It is the foundational sacred document, and it is from where all law must be tested. But the actual law that regulates free speech and hate speech is the Equality Act. It's an unusual piece of legislation. It's described as sui generis in that it is neither solely criminal nor civil. You cannot be incarcerated under the Equality Act for an act of hate speech or discrimination or harassment, but you can be fined. You can have a license stripped away, and you can be made to apologize. And for a long time, there was quite a bit of ambiguity as to what's the law actually required. I think the first time that most people in this room will have heard of the Equality Act was the Penny Sparrow case. Penny Sparrow says this undoubtedly racist thing. She compares black people to monkeys on a beach. The timing of it is rather extraordinary because a few weeks before the country was galvanized against Jacob Zuma for having fired our Minister of Finance. There were these big parades, Zuma must fall, the press was very focused on this. And then suddenly this real estate agent from the middle of nowhere became front page news for a year and a half. And the threshold that she was held liable for is very different from that mentioned in the Constitution. What was found was that her speech was hurtful speech, and on that basis constituted hate speech. So what the Equality Act had done was say that hate speech is the incitement of harm, harmful speech, hurtful speech. And there was an ambiguity as to whether all of these things should be present or any one of them was present. And the court said, we're going to go with all, which means you go to the lowest possible threshold, so hurtful speech. I was then briefed in a case against Valapi Kamalo. And Valapi had responded to Penny Sparrow by saying that we should do to white people what Hitler did to the Jews. They should be burnt alive, hacked to death, and their children turned into garden fertilizer because they're all a bunch of racist fuckheads. And so a complaint was raised against Valapi, and we saw this as an opportunity to do two things. The one is to get some clarity on what the law actually is. Is it merely hurtful speech? Or does it require something more? And the other was to hold Valapi liable. It's quite clear that there is an actual call to violence, that there's a call for mass slaughter of people on the grounds of their race. And so quite easily meets the high threshold test mentioned in the Constitution. There was a third issue that came up, which is the issue of non-racialism, something that the Institute is very good at championing, and one of the few organizations that champions this value that's in Section 1 of our Constitution, by the way, it's largely forgotten. This idea that regardless of the race of the speaker, and regardless of the race of the group that's being targeted, the law will be applied equally. And so Judge Sutherland in the Kamalo case really sets us on a path that develops our hate speech law. He says, all are equal before the law. It doesn't matter whether you're part of an ascendant group or a minority group, all are equal. That it's contrary to the value of free speech to interpret the Equality Act in such a manner that merely hurtful speech would constitute hate speech. And so he interprets it conjunctively. So hurtful and harmful and incites. And Valapi was held liable on that very high standard. I then appeared in a case which is now regarded as the locus classicus in hate speech case, which is for John Quilani. Now, some of you will know John Quilani as an anti-apartheid journalist, and who's also quite deeply religious. And he wrote an article in 2008 about gay marriage. I think it's worth sort of thinking about the context of the time. So in 2006, South Africa was the 5th nation in the world to grant gay people the right to get married. I think this is a wonderful liberal victory. Our constitution makes it quite clear that you can't discriminate against people on the grounds of their sexual orientation. But it was quite a heated debate at the time. The Constitutional Court ultimately opened the way for gay marriage, but itself recognized that this is a highly politicized issue, that people feel strongly about it. Secular people and religious people might be opposed to it. For some people, it's not just immoral for gay people to be married, but it's inconceivable. That baked into the notion of marriage is the idea that there must be one man and one woman. And so the Constitutional Court says this must be determined by the legislature, and they gave them 2 years to have public hearings and hear from the public about what their views were, ultimately decided that gay people should be allowed to get married. And around this time, Quilani writes his article, and he says, I pray that politicians would have the balls to change those parts of the Constitution that allow a man to marry a man and ditto a woman, because one of these days, some idiot will demand the right to marry an animal. And the headline of the article was, Call Me Names, but Gay is Not Okay. An article and a headline he didn't write, next to a cartoon, which he didn't make either, of a man marrying a goat. And the priest saying, I now pronounce you man and goat. So Quilani then received, I think, the largest number of hate speech complaints the Human Rights Commission ever received, and in the trial process was held liable for hate speech. And in the course of that trial, a lot of evidence was led about the harm of the speech. The most famous piece of evidence that was led was by a woman whose name was kept secret, but who was a black lesbian living in a township. She talked about the horrors of being black and gay in a township community, and the corrective rape that would occur, and the impact that these kinds of articles could have. Although when asked whether there was a direct causal link between this article and what had happened to her, she said no, but that it added to this climate. And there was evidence from academics talking about how these sort of things can sort of shape the climate. So Kulani was held liable. I then appeared for him, not in the trial, but in the Supreme Court of Appeal, and later in the Constitutional Court, and we challenged the constitutionality of legislation. And the Supreme Court of Appeal took the view that while Sutherland was doing something valiant in adding in these ands to kind of firm up the free speech rights, that the text itself couldn't really be fairly interpreted in that way, and that it was just outright unconstitutional. And it was declared as such and replaced with the language in the Constitution in 16.2c, this idea that hate speech is advocacy of hatred against group, race, gender, ethnicity, religion, and you'll note sexual orientation is not listed. Now, we have a thing called the limitations clause in our Constitution, which is the idea that you can limit rights if it's reasonable to do so. And part of the argument before the Supreme Court of Appeal was the Constitution knew about gay people, it protected them in the equality cause. It wasn't that it was an oversight. They deliberately decided not to protect them with hate speech. Can we protect them now? The Supreme Court of Appeal said we can, that it's an analogous ground, that there's enough history of persecution against gay people around the world and in South Africa to include them in that category. But once they declared the act unconstitutional and put in this new interim test, they said, well, we can't hold Kulani liable because that's not the test that was in place. Then it went on appeal to the Constitutional Court, and that case is now the kind of gold standard for determining what hate speech is. And the court recognizes a few things. The one is to say that you don't need to prove this causal link between the speech and real world harm. They ultimately find that the term hurtful is unconstitutional, and they strike it out. But instead of striking out the clause, they decide to do some precision surgery, and so add in a whole series of other grounds which were in the act. So sexual orientation is there, but now language, culture, marital status are all included in protected grounds as well. And they ultimately hold Kulani liable. He had died during the litigation process. So the original article was written in 2008, and the judgment was handed down, I think, in 2022. So if you feel like your case is taking some time, well, spare a thought from Mr. Kulani. The Human Rights Commission at the time had called, I think, on his family to apologize on his behalf, and the court thought that was beyond the pale. Now, what Kulani did was sort of create this framework and an expectation that we now know what the hate speech law is. It's quite a high threshold. Merely offensive speech will not be viewed as hate speech. The court explicitly recognizes that. It says that speech which is shocking, disturbing, or offensive is protected. You must meet this high threshold of harm. Harm sort of implies like a deep psychological trauma, the kind of thing that could be proved by a medical professional. And so it was then surprising to see how the old South African flag was dealt with. So I don't think there's much love for the old South African flag among South Africans. So much so that the litigation didn't involve a flag waver. There was no person accused of waving the old South African flag. It started on the basis that there was a debate between two CEOs of different NGOs about whether it would be a good idea or a bad idea to ban it. This is an unusual thing in that basically South African law says that you must have a live set of facts before you can go to a court. You can't just say, hey, we're having this debate, could you resolve it for us? You're not supposed to go to courts for opinions. But an exception was made in this case. And one of the arguments made by AfriForum in that case, who took the view time, there was a feeling that this is now done and dusted. And I sort of thought, I imagine that the issue will crop up again. And it did in an interesting way during our elections. So Jacob Zuma's daughter, after the GNU was announced, created a logo of the African National Congress in the colors of the old South African flag and used the old South African flag instead of the ANC flag in that shield, and decried them as a bunch of racist sellouts who were just like the National Party. An example I'd given the Supreme Court of Appeal, and they found that kind of laughable. And so there's an interesting question as to whether MK have committed an act of hate speech by publicly displaying the old South African flag. But there wasn't much outrage from the press. One of the interesting things about the flag was that I think I gave a lecture about it at Wits University, and I asked the students in the room, the last 6 months, this was at the height of the litigation, how many of you have seen the old South African flag? And 300 students in the room, everybody's hand goes up. They'd seen it absolutely everywhere. Newspapers, on television, whenever there was any kind of press announcement behind it, you'd see the old South African flag waving behind the presenter. And I said, go back 5 years. How many of you had seen the old South African flag then? 2 hands went up. Almost never. So you had this backfiring effect in the banning, and you had a lot of people who would have found the flag a rather offensive thing that they would never have affiliated with, suddenly seeing it as a flag that represented something else besides apartheid, but a symbol of freedom. So you had people using the flag or its colors to sort of push back against the state. And so there's always this danger that if you ban speech, you'll get a pushback and you'll change the meaning of the symbol. The other case that I'm sort of known to have worked on is the Kill the Boer case. And here we thought that the way to run the trial would be in a manner that mirrors the Kolani trial, to lead evidence, to show the dangers of some forms of speech. So here you had the leader of the time, the 3rd biggest political party in the country, standing at stadiums filled with 90,000 people, singing Kill the Boer, calling for an ethnic minority group to be killed. And so we led broad evidence about farm murders and about how disproportionate those numbers look in comparison to other crimes in South Africa. So the murder rate in South Africa is roughly 33 out of 100,000. So the standard way of measuring crime in countries is to do it out of this under 100,000. So you have a per capita rating. Now, it turns out that actually only about 5 out of that 33 are intruder attacks. A lot of murder happens between couples or in bar fights, and actually quite a small portion of it happens through intruder attacks. Farm murders, by definition, all happen through intruder attacks. And there, the farmer murder rate, so in other words, if we count the number of farmers there are in South Africa and how many of them are killed, it's about 100 out of 100,000. So 20 times the sort of national standard. So that it's more dangerous to be a farmer than it is to be a police person. That seems kind of outrageous thing, not the case anywhere else in the world. And so we led this sort of broad evidence. We then led the evidence of people who survived attacks, whose spouses had been murdered in front of them. And we then, I had the opportunity to cross-examine Mr. Malema. And one of the advantages of that trial was that it was televised. So you had this opportunity to hear from Mr. Malema himself what his actual views were. And for 8 hours, he testified under cross-examination and said some rather unbelievable things. He said that when the conditions on the ground were right, that he would not hesitate to kill, that they meant it when they sang these songs, that they would bomb the union buildings, that when asked about Kill the Boer being written in blood over the murdered bodies of a mother and daughter on a farm, whether he viewed this as an act of racist murder, he said no, and refused to denounce his infamous call for slaughtering white people just now or now. I asked him to pledge whether he would say, I'll never do it, and he refused. So that was a very interesting opportunity to kind of get a sense of what are the actual values of the party. What was, of course, astonishing was sitting in court every day, seeing this presented, and then reading the paper in the evening and seeing a very different gloss. But there is a good public record of it, and a number of years after the case was concluded, Elon Musk tweeted some snippets from that trial, which were viewed, I think, about 30 million times, and caused a general sense of alarm, accompanied by footage of Mr. Malema singing Kill the Boer at stadiums. By the way, the line at the time was that they would never sing Kill the Boer, they would only sing Kiss the Boer. And during the trial, one of the days when we were coming into court, a band of EFF guys blockaded the entrance and then quite explicitly saying "kill" at us and mimed rifles. They then had to abandon this sort of claim that they were only blowing kisses, and have ever since then saying explicitly "kill." That case went off to the Supreme Court on appeal after the court found that all of the evidence that was led was irrelevant, and that it could be discounted because there was no causal link between the speech and anyone being killed. An outright defiance of the test set by the Constitutional Court in Kolani. There was also a view that Boer is a very hard word to understand, very ambiguous, and the best way of understanding is that actually it refers to the ANC government. This is the ultimate finding of the trial court. I imagine all of you thought that as well. When you were studying the Anglo-Boer War, you thought it was the British fighting the ANC. So that matter now will go on to the Constitutional Court. I'd like to talk about some other issues that are a bit sensitive, but I think are important. So I mentioned this idea of academic freedom and why it's important that universities are given an enormous amount of space to explore strange, weird, and wonderful ideas. John mentioned that I run a philosophy discussion show called Brain Navat, and we've interviewed about 250 academic philosophers from around the world, and people will say all sorts of incredibly strange, wonderful things in philosophy. About half of the episodes that we do are on moral philosophy, so there'll be vigorous debates around abortion, around immigration, around sexual taboos, all of things which philosophers do quite easily. The idea is that we try and understand someone's position, that we ask them a series of clarificatory questions to know what it is they're actually espousing, what the view is, and then we give a series of objections, regardless of what our own personal beliefs are, to try and see how well the view does under scrutiny. And this is kind of the lifeblood of philosophy. That is how philosophers behave in this cold, civil way, where we try and engage and we scrutinize and we test, try and follow the scientific method to find out what's actually true. We do it in the normative space as well. And it seems to be the case that the place that's hardest to speak your mind nowadays, not just in South Africa, but globally, is the university. That in 2015 or 16, Fleming Rose was invited by the Academic Freedom Committee to give the annual T.B. Davis lecture in the name of free speech. It's an academic freedom lecture, and it was cancelled. And that sent a signal that certain views will not be tolerated. There was a threat of violence at the time, which was taken very seriously. And the idea was that if we submit now and cancel the lecture, that we will then save ourselves. And of course, once you submit to the heckler's veto, it becomes very hard to not keep on submitting. And UCT has submitted again quite recently. So the new Vice Chancellor, who's been in office for about 2.5 months, announced a Vice Chancellor's lecture where he had invited Mr. Senst, who was the editor-in-chief of Bild, which is a newspaper in Germany, and to speak on democracy and AI and the media. And a targeting campaign was run to say, well, Bild has on occasion taken a pro-Israel stance, and therefore you cannot allow this person to speak. And the Vice Chancellor said, we are going to hit the pause button and put the lecture on hold. And in the face of this sort of public pressure, that lecture is not occurring on the date that it was agreed to. And we'll see whether UCT is able to steer its way through this difficult situation. I will say that there is thought given by the Academic Freedom Committee to have a series of lectures about the importance of academic freedom and what it actually means. You will find yes. So I will say that this is worth recognizing, of course, that the IR stepped up when UCT wouldn't. And I was at that lecture, which was held on these premises. And there was no violence. No one got their head chopped off. David Benatar, who's in the philosophy department, also invited Fleming Rose to speak, and there was, again, no violence. So it turns out people are able to speak their minds without getting decapitated, and you should remember that lesson. So yes, there's a situation where academic freedom remains on the line, and there is a debate about what it constitutes. And the one view is that academic freedom is about giving each other hugs, that it's about feeling safe and comfortable, and making sure that your feelings aren't hurt. And how could you be free if you feel little niggles? Whereas the typical philosophical view is that a talk is successful if we've left a stone in your shoe. If you walk out of here feeling quite uncomfortable, you can't quite get rid of that stone, and you have to, slowly think about the positions that you once held. Now, there are some people who are able to take a brave stance to host speakers or those who hold strange views. And one of the people who's done that for a long period of time in South Africa is Ramon Kabanak. So Ramon ran the Renegade Report on Cliff Central for a number of years with Jonathan Witt. They started around the time of the sort of Fees Must Fall movement, and a series that I think was intended to last 6 episodes went on for a number of years, and they had hundreds of episodes. And they spoke to people across the political spectrum, people in all sorts of different political parties with different views, liberals, conservatives, traditionalists, and they interrogated their ideas. They heard them out. They said, give the person an opportunity to speak. Let's find out what they believe. And they entertained all sorts of strange, weird, and wonderful views, many of which I would like and many of which I wouldn't. Ramon then went on to start another show called Morning Shot, which exploded during COVID when everyone was stuck at home. They spent a lot of time watching Ramon at 6 a.m., having their morning espresso and hearing many of his views. And he was then invited to become the chief of staff of John Steenhuisen, which is when many of you all heard of Ramon for the first time. And I don't think anyone in this room or anyone watching online could name another chief of staff in the country or one in South African history. It's unbelievable how infamous Ramon became during those 2 weeks. The levels of interest in the few tweets that are still available and the levels of pressure put on the DA to ensure that Mr. Kabanak would be defenestrated were immense. There was much debate, as far as I can tell, within the IR about its own views. That I don't think Ramon is a classical liberal in the sense of the IR, but he's in favor of things like free markets and private property rights. And I think some parts of the Constitution, maybe not all of them. One of the parts of the Constitution that he spoke in favor of is the recognition of monarchies. So some of you will know that we have, I think, about 13 different monarchies in South Africa. And this is consolidated down from about 27 and officially recognized in our Constitution. And ultimately, pressure was brought to bear on Mr. Kabanak, and he was asked to resign. Now, I think many will have celebrated this and said, what a wonderful victory, and we've managed to get this terrible fascist guy out of government. But it does set quite a dangerous precedent, which is those that are willing to do something a bit experimental, those that are willing to entertain strange ideas, might not do that anymore. That it might be quite difficult for Mr. Kabanak to be embraced after this public drubbing by the press, after you've been called literally Hitler for a couple of weeks. It's hard to recover. And so I think one of the things that matters about free speech is not just the right to free speech, but adopting a culture of free speech, where you allow people to say things that are offensive and you say, that's okay, that I'm not going to agree with everything someone says. If I think about cartoonists like Sapiro, he has been very good at pushing back against the powerful, at making fun of various presidents. And he's also taken lines that I find utterly repugnant and despicable on occasion. And I think you should be able to do that. There is another interesting incident of a call for someone to be cancelled recently, which is Dr. Imitaz Suleiman, that was very ominous. So Dr. Suleiman is the founder of Gift of the Givers and has been invited to speak at the Hill and Suzman Foundation's Memorial Lecture. And an article came out recently pointing out that Gift of the Givers has a strong relationship with not just Palestinians, but with Hamas, that an organization that has funneled 6 billion rand may very well have funneled cash to an organization that is in many countries regarded as a terrorist group, although not in South Africa. And it was pointed out that Helen Suzman was quite keen on Israel, and although not religious, was very much against anti-Semitism, and that it seemed to not mesh with the values of that organization to have someone who openly denounces Israel in very strong terms, quite happy to call Israel a genocidal apartheid colonialist state. And the Helen Suzman Foundation has decided to have the lecture anyway. They said that they care about free speech, and they care about the rule of law, despite Dr. Suleiman saying that he doesn't see himself bound by South African law, that he is only bound by Quranic law, and that he has broken the law on many occasions. He said this on public occasions. And there is some value in that lecture going ahead, which is that the Helen Suzman Foundation has told everyone what kind of organization they are, that they think that Dr. Suleiman is someone worth venerating. And that's information. And I'm sure many of their donors will make choices based on that information. And I imagine that the lecture will go ahead and many will be able to see what Dr. Suleiman has to say for himself. But thank you for listening to me. I hope I haven't thoroughly besmirched the reputation of the IR. But I look forward to hearing some of your very probing questions.
Thanks, Mark. Sorry, just to apologize, particularly to our streaming viewers, our lighting overheated, and I clearly didn't make my request for increasing the lighting in the room understood. So it went the other way. Any questions for Mark?
Mark, two questions, very different. John Kolani case, the kind of precedent it creates, would it be correct to say that if the Pope went on the world tour, came to South Africa, and held a public mass at Loftus Fairstone, preached the traditional Catholic view on marriage and homosexuality, that he would then be charged with hate speech based on the John Kolani precedent? The second is, there seems to be, particularly in the UK, some recent incidents of religious individuals standing very quietly outside an abortion clinic and doing nothing other than engaging in silent prayer, where they've been arrested and imprisoned. And of course, the cry goes out that we're now dealing, we've got into the realms of now policing thought. Although you've got to ask the question, is that an act of freedom of thought or freedom of expression? And where is the line? I'd appreciate your comment on that.
Excellent, both great questions. So during the hearing of Kolani, which by the way is publicly available because it was argued during COVID, and so you can watch the whole 7-hour hearing on YouTube. It's a wonderful document for those that are interested in seeing how courts decide and watching the interactions. There's a moment where I say, when we look at Mr. Kolani's speech, we need to compare it to speech that is commonly protected. And I made a bit of a show of taking out a copy of my Good News Bible, one of those Bibles that you find in churches across the country and many homes across the country. And I read out some passages, one of which I think from Leviticus says that when a man has sex with a man, he commits an abomination, that he is deserving of death and that his blood shall be upon him. There are other lines in the New Testament that mirror this kind of language, the idea that it is despicable to be gay and that you are deserving of death. And I compared that to what Kolani said, which, by the way, says nothing about gay people at all. It only questions this idea of gay marriage. And Kolani was, on many occasions, said he has gay friends and he has no problem with gay people, only with the idea of changing the institution. And one of the judges said, well, so much worse for the Bible. If that's what it says, then I guess we shouldn't allow that either. So they were willing to bite the bullets, at least in the interaction. But there's another sense in which it's an important question, because maybe what happens is that the rules aren't applied evenly. That when it's Kolani, we can kick him in the teeth. But when it's the Pope, we say, well, that's okay. And that's what we sort of see with Jacob Zuma's daughter. that some people can wave flags and others can't. Some people can call for the killing of ethnic groups and others can't. There's an immense danger in going down that route. And it's not just a matter of courts failing to apply the law. It's that you actually have a parallel system of thought, which is that that's what they ought to be doing. That the idea of equality before the law is actually a bad value, and that you need to, first of all, consult a pyramid of privilege. It's quite simple. What you do is you take the Ku Klux Klan one, and you do that to it, and then you sort of work out who's on top and who's at the bottom, and that tells you whether someone's liable or not. Again, something that is condemned by Judge Sutherland in the Kamalo case, but there is definitely a danger that if you are powerful, or you're in the right protected group, that you'll be free, and if you're a minority group, well, then you get kicked in the teeth. And so that idea of equality before the law, very worth protecting. In the Supreme Court of Appeal, I acted for the Free Market Foundation's Rule of Law project, and we were very keen on making that point, and that video has been viewed about 40,000 times, and worth watching. What's interesting is that in Kwalani, the court specifically says that when you're evaluating speech, you should take into account what's called the rebut plan of action, which is an international law standard about taking into account the context of the speech. And one of the things is, how big is the space in which you speak? So is it, one-on-one interaction? Is it a stadium? Are you a nobody, or are you a person of public prominence? And they entrenched this test in our law. But in the application of it, it's been entirely inverted. That the politicians who can command tens of thousands of people are exonerated, and the nobodies are punished. Then with regards to the silent prayer, so there's an interesting question about what counts as speech. And one of the issues in the flag case was that the act that regulated it didn't refer to speech or expression, it referred to words. And so one of the points taken was, well, a flag isn't a word really, right? And we had a long, interesting Humpty Dumpty debate about, words will mean whatever I say they mean. And it turns out that a flag's a word. But if you go to Section 16 of the Constitution, it uses a broader thing like expression. There's a famous case from the 60s in America where someone was prosecuted for wearing a T-shirt that had this symbol and the draft. And the question was whether that amounted to speech, because it was a symbol, and the view was it does. Flag burning was viewed as expression and was viewed as protected. So I would think that silent prayer would amount to expression and be protected, while also being protected under freedom of thought. And it is interesting that we find that free speech is under attack not just in South Africa, but around the world, and actually in Europe more so. That if you look at the nature of those laws, they are rather frightening in their scope. The hate speech bill, which first appeared on the scene in 2016, wanted to criminalize speech in South Africa and included the idea of insulting speech or ridiculing speech. And the guys who came to save the day were the satirists and the stand-up comedians who said, listen, you're going to make illegal what I do for a living. It's important that we're able to make fun of each other. And so those portions of the bill disappeared. It was ultimately signed into law, and it looks very similar to the Equality Act. But of course, there's a rub, which is that while the Constitutional Court in Kwalani sort of made some exceptions and said, well, we're only going to make you apologize or make you pay a fine. So I guess we can sort of limit speech in these ways and deviate from the constitutional order. They don't require incitement to harm, for example. The Hate Speech Act will incarcerate you. And so there is this worry that now a piece of legislation has been crafted like a weapon that could be used to terrorize people. Now, what's interesting about it is that during the drafting phase, it was pointed out to some of the politicians, power doesn't always remain in one party's hands. It might be that this will be used against you. And of course, they chuckled and said, but the ANC will be in power till Jesus comes back. Maybe not. David. Michelle.
Thank you. Mark, you referred to one particular DA appointment, Chief of Staff, but there was another one which created equal, if not worse, media storm, the Ronaldo Gous case. Would you please comment on that?
I will have to limit my comments because of the bar rules, but I will say things that are in the public domain, which is that when the case was first reported, a 15-second clip of Mr. Ho speaking from 2010 was reported. And I think anybody seeing that 15-second clip would have been quite alarmed by what was said. Once the full clip came out, it became quite clear that Mr. Khoes had used a phrase to provoke a reaction about Kill the Boer. He said, "What I have just uttered is despicable." And many of you will have felt immensely hurt by that. Well, that's what I hear when I hear Kill the Boer. And as much as you should condemn what I initially said, because I don't mean a word of it, you should condemn Kill the Boer. And by the way, at the time, in 2010, Kill the Boer hadn't been sung for a very long time. It was sung by Mr. Malema, it had been sung by Peter Makaba in the 90s before, but it was seen as a big provocation and was at that time held to be hate speech a year later in 2011. And the outrage that came after Mr. Khoes is rather unfortunate in that what you had was IOL publishing an article, probably having access to the full recording and only releasing the first 15 seconds. Mr. Khoes complained about this to the press council. He was successful. IOL took it on appeal, but have since decided not to abide by the press council's decisions and have been ejected. So that gives you some indication of that. Yes.
Hello, Mark. David Ansari from the Free Market Foundation, one organization which has benefited from your legal services. And I think my question relates to the importance of strategic litigation, not just on hate speech, but more broadly in terms of engaging in this battle of ideas that civil society groups like ourselves and the Institute of Race Relations are participating. And I was wondering if you could talk about the importance of that and also some of the limitations of that strategy, given that, as you outlined, often there seems to be quite a high degree of variability in the judgments that are handed down by various benches. And you also, in particular, in this GNU era, and we have warned against GNU for that there are many battles still to be waged in the name of freedom. One of the risks is that with the GNU, you have, for example, the DA pulling back on some of its strategic litigation, like most notably on NHI, preferring to retreat behind the closed doors of cabinet beyond the view of the public, trying to work those channels. That may or may not be an effective strategy, but I think it's incumbent on civil society organizations to fill that void and engage even more vigorously in the courts for those important victories.
Very important. That we must recognize that there are a few different centers of power in South Africa. There was recently a public letter from a prominent firm of attorneys pointing out that NGOs have shouldered an enormous burden in running litigation to hold government to account, often on shoestring budgets, and that corporate South Africa has not come to the party, even when this litigation is for its interests. That litigation is expensive, it's time-consuming, it requires support, and that if you want to live in a free country, it's important that you support it. Now, it's a long, hard road fighting the courts. I mentioned how long it took in Kulani's case, but often for small amounts of money, you can have enormous gains. The one that springs to my mind is a piece of litigation brought by Sakaliga around preferential procurement. And you had a regulation put in place by the Minister of Finance, which basically excluded businesses from participating in the tender process based on the race of the owners, and regardless of the race of their employees. So you'd have this sort of sinister situation where a company like Fidelity Guarding Services, which employs about 50,000 black employees, wasn't able to enter into the bidding process because of who owned the company. So, many of those people would be driven into poverty in the name of transformation. And so this was challenged, and they were successful, and they were partly successful because the Free Market Foundation's Rule of Law Project joined in those proceedings as a friend of the court. And for a rather paltry sum, they were able to overturn this law, which opens up billions of rands of value for all these businesses, not just for the businesses, but for the taxpayer. So one of the things that happens in the bidding process is when you're trying to determine the price of what should government pay for something, there's a kind of point system put in place on the grounds of kind of BE things. And by the way, this is not how the Act was originally envisaged. It was race neutral in its description and referred to disadvantaged individuals. And it only really gave it for these sort of contracts that were under 50,000 Rand, and that was amended to 50 million Rand. And then disadvantaged was kind of started to refer to racial categories. But it was a price checker. So basically the person who was second was still kind of bound by, the guy who came in cheapest. And if you can remove the cheapest guy because he's the wrong color, it suddenly changes the landscape of what's at the bottom. And so you had this inflated cost in all these services. And a lot of those services are really services for the poor. So the state only has so much money to spend on public housing, on public bathrooms, on public schools. And say, well, I guess that's what the going rate is, so we're going to have to build less of it. So that is an incredibly pro-poor decision as well. And the Rule of Law Project in particular has done quite an incredible job in getting involved at the level of the Constitutional Court, talking about the importance of equality before the law, and caring about the value of non-racialism. The IRR played a very important role during our elections. There was a move to cancel our municipal elections in 2021 on the grounds of COVID, and the IRR played a pivotal role in ensuring that didn't happen. And under enormously difficult circumstances, because I think it was an urgent hearing. It was the first time the IRR had to go to court, and it was argued within 2 weeks, and ultimately the right result happened, and we all voted, and kind of played a role in saving democracy. So I'd say that it's important to identify those NGOs that are fighting the good fight. Unfortunately, some of the once regal ones are no longer regal, that they have fallen into abeyance through lack of funding, or that they've been captured by something else. But there are still some really good ones who deserve support from the people in this room, those that are watching online, and those that care about freedom, dignity, and equality are our foundational values.
Sorry, Mark, can I ask a question while I go to...
With pleasure.
The question, and that is that the ANC has gone completely quiet on the hate speech act since the election, since it formulated the GNU. Does it have better things to do than you know? Or are we inevitably going to go down the Hemisphere road that we're experiencing in the UK and attempts in New Zealand and Australia to criminalise people for saying horrible things, but hardly what I suppose we would consider justifying sentencing to imprisonment?
It's interesting because you had a flurry of very controversial laws being passed by Parliament just before the advent of the GNU. So Bella and NHI and the Hate Speech Act. But they haven't been operationalized or signed yet. Bella has sort of, portions of it have been paused. The Hate Speech Act hasn't been operationalized at all. But it sits in abeyance as a bit of a threat. And maybe it will dawn on people that it will be a weapon used against them as opposed to the others. Of course, an overconfidence among politicians can sometimes backfire. And it'll be interesting to sort of see who the first martyr is of hate speech act if it is signed into law. I think some people feel an enormous amount of freedom to say quite despicable things that probably do meet the high threshold envisaged by the law, but will never be held to account because of their power and their status and their popularity. But things can change.
My question today is more along the lines of free speech, and perhaps should there be a limitation of it to only humans? I know it's a weird sort of question to pose, but we're seeing a lot of stuff online that's been generated by bots. And earlier we spoke about the idea that truth, if we have free speech, the truth can fight against lies. What I'm seeing online is a lot of sort of bots, a lot of affirmation of those lies. where they drown out the lies. So would you advocate, not necessarily for a limitation on free speech in general, but perhaps a limitation on free speech to humans only, rather than allowing governments to make use of bots or entities to make use of bots to promote untruths that are dangerous to free speech?
It's a good question. I suppose first thing to think about is when a bot says something, is it autonomous? Is it, in other words, an agent that can deliberate and think and decide what it's going to say, in which case it starts to look like a human. And maybe we start to think that beings like that are worthy of the rights that we have. And the other view is, well, they're not sophisticated in that manner, that they're actually just the tools of human beings. And so human beings have found a method for expressing their own ideas. So I think under either situation, the view would be to protect it. It does raise a different problem, of course, which is that gossip and lies will spread all around the world before the truth's laced up its trainers. And we got to see really interesting versions of this during COVID. A lot of people were locked up at home. You had conspiracy theories that like spreading around in all sorts of different directions. It took quite a while for people to work out what's actually true. And there's an overwhelming sense of getting information. And the difficulty is that people often throw their hands up in the air and they just go, I just don't know. And especially when sources which were once trustworthy get caught out lying or involved in bad conspiracy theories. I mean, when Elon Musk took over Twitter, he sort of uncovered a fair amount of stuff that the old regime had done in collaboration with government. That you had a kind of pact between the Silicon Valley guys and government guys about which speech would be censored and which speech would be elevated. And, so it is difficult to allow people to say bad, pernicious, false things. And it does require maybe a level of faith that ultimately the truth outs. And sometimes these fights are long. One of the examples that I often think about is a famous case called the Scopes monkey trial. A film called Inherit the Wind was made about it. It's about a law passed in the Deep South in America banning the teaching of evolution at schools. And it was called the Scopes monkey trial because you had people who would stand outside courts with monkeys and they'd say, it's inconceivable that we descended from monkeys. These guys are lunatics. And, the way people remember that case is they say, oh, the good guys won, right? They didn't. They lost the case. And that law remained in effect for decades until it was eventually overturned. And so sometimes the fight for worthy values takes time. And the bad guys win for quite a while. But it does seem that the general trajectory of human development is that if you embrace these classical liberal values, that you wind up in a much better place than the short-term solutions of censorship and control and totalitarianism, which often lead to many people piled up in mass graves.
So we have last question. Thanks, Mark. My question isn't fully formulated in my head, but I suppose it speaks to the framework in which hate speech operates in South Africa. It sounds like all of our hate speech laws from a constitutional level right down achieve their objective, including protecting the individual, but by virtue of protecting the group, which I think is quite interesting, especially when you start to consider the subjective nature of harm. I just wanted to know if you could speak to that in light of the fact that the case that I'm able to recall is the plain word case with Adam Katsavelos, where he had formed himself, and I understand that there was a lot of talk about free speech as it related to that, and he was ultimately found guilty on the basis of criminal injury, being the common law injury to the dignity of a person or a people. Is there not a bit of a contradiction that exists if harm is removed, but it is then found in, for example, the common law?
Yes. So from what I recall with Katsavelos, it's an interesting situation because what he does is he broadcasts something to his friends while he's on holiday in Greece. It's not aimed at an individual. So crimininjuria, the common law sort of thinks of it as when you engage in like an extreme interference with someone's dignity to that person. So like an assault. So I punch you in the nose. That constitutes criminal injury. And so the Vicky Momberg case is an example of that. And Casavelos doesn't do that. There's no person he speaks to. He I think, was ultimately put in a situation where he was, made to publicly prostrate himself and enter into a settlement deal with the Human Rights Commission. It's unclear if that litigation had gone on a hate speech case that he would have been held liable. Of course, there's a difference between what the law says and how it's operationalized. But we do have a range of remedies for individuals. So if I defame you, I say that you're a bank robber and it's false, you have a claim against me. And so hate speech laws are, in some sense, thought of as group defamation, where I'm not tainting a particular individual, but I'm casting aspersions on the group. But the idea is that it does require something more than merely casting aspersions, that hatred is this very high threshold. So the case law sort of talks about extreme acts of vilification. I think it's preferable to have incitement as a requirement. As I say, our law in the Equality Act doesn't. That can be viewed as the words themselves are harmful. And then, of course, there's a question as to what counts as harm, and is it going to be basically reverting back to you hurt my feelings, and the Constitutional Court says it can't be that threshold. But it does seem to be at least a slippery enough term that even if you lead evidence from clinical psychologists, for example, that when someone who's had their wife murdered in front of them hears kill the boy, that it's incredibly traumatizing for them, that evidence will be disregarded. But the mere notion that someone waving an old South African flag somewhere is obviously harmful will be accepted without any evidence. So there's that balancing act to be done. There's a danger in not having clear definitions, and that's why I started off with my original case of I know it when I see it. And I think a lot of us still have that inside of ourselves, and that includes judges. It'd be nice to include one more question, and there's a hand at the back that I'd like to hear from.
Thank you very much. Mark, great conversation and speech. Thank you very much. I would like to talk about the K word, but my surname starts with a K. So I remember one kid, somebody said on the radio, they used the K word, and Kaneko said, Uncle Muzi, what's a K word? And the problem was, I know the court has said we can't use that word, but then it takes away the fact that, for Musa, I once asked the question, so what we've done is we've kind of sanitized history, and when it's okay, when people play hip hop and say niggas and this, but the South African hip hoppers can't say gaffers and that. So how do we change that?
Fantastic question. I will say this, it's become incredibly hard to have the meta conversation about this point, right? So you wind up in a situation, the question came up earlier, where you talk around the point because we have this quasi-ban. I will say there is no actual ban. The Constitutional Court uses the term, I think, about 32 times in one of its judgments. It doesn't say K-word, it uses the word in full. Pierre de Vos wrote an article in 2008 where he said, the Americans have been very good at changing the meaning of a word like queer. So queer was used as a term of abuse and is now used as a celebratory term. And he said we should do the same with mofi and the other unutterable word. And he doesn't say K-word either. So there is a sense in which there was a move to try and say there's some value in being able to take out the sting of the word. Trevor Noah had a sketch in 2012 where he got his audience to shout the word and call each other the word. And he said we should have a national day where we do this annually and take out the sting. And there's interesting situations in America where this conversation goes. There's a famous case of an executive working at Netflix who said, we've got a lot of comedy specials where the comedians, utter certain words, and I'm quite uncomfortable with them. And he says the word, and they say, "How dare you say the word?" The same thing happened to our former vice chancellor at Wits when he moved to SOAS. So there's this strange gotcha game of basically you said Jehovah. The sketch that I think of is from Monty Python's Life of Brian, where the high priest is sort of standing in front of an august crowd, and he says, this man before us has committed the extreme act of blasphemy which deserves death. So what do he say? Well, he said Jehovah. And so the crowd start throwing stones at the high priest because he's said Jehovah, you know. And he says, but all I said was that this meal was fit for Jehovah. He said Jehovah, and they stone him. And it seems like we haven't really learned our lesson from a joke that was made 50 years ago, that there's a danger in saying certain words are unutterable. And I think it comes from that blasphemy instinct, but it's a very infantile way of thinking about the problem. And as you say, it has a further problem, which is that you then can't talk about your dark past, you know, and then you can't see the terrible things that happened. So, yeah, thank you for raising the question. And thank you all for attending tonight.
I'd like to now call Pereira, who has our insight, to give us a big vote of thanks.
Good evening, Madam Chairman, ladies and gentlemen. On behalf of the Institute of Race Relations, it is my great pleasure and indeed my honor to thank Advocate Mark Oppenheimer for this insightful and timely Hoernlé Memorial Lecture. I was particularly taken by your discussion of things such as the importance of free speech in searching for the truth and its role in individual agency. I thought that was a very good way to frame the discussion in the first instance. And of course, also your observations over the narrowing of what many people will tolerate in particularly recent years. And Sarah Gon mentions some of the restrictions that have come into play in the United Kingdom in just the last year. The one thing that's always amused me about what we don't tolerate in our constitution is propaganda for war. You know, sometimes you face an enemy and you need to propagate for war. So I don't know what we would do if Adolf Hitler was on the stage at the moment. So I think that sort of thing is actually morally neutral in its essence. But you discuss so much more besides. It's a timely discussion, as I say, but sadly, there are not, I don't think, many organizations in South Africa who would dare even touch the topic. That's a great shame, given its absolute necessity and relevance to the protection of our rights. So kudos to Institute CEO John Endres and his team for giving us this opportunity. And lastly, thank you to all of you for attending the lecture, for your support of the Institute, and for your careful engagement with our discussion tonight. Muito obrigado.
Thanks, Paul. Thanks, Mark. And thank you for attending. And it's really good to have an audience both live and streamed. And we hope it wasn't unduly affected by some of the catering and the lighting problems that we had. And I hope we'll be able to do this sooner again rather than later. Please join us for some eats, some drinks, and some discussion. Thank you very much for coming.